Now, Gary, I've seen you take a lot of depositions of adjusters through the years on these bad faith cases.
Right.
What are some areas that you question adjusters and request information regarding their decisions when going over the claims file?
Sure. Did you treat your insured's interest the same as yours? Did you look for coverage and did you explain it to your insured? How did you value, Mr. or Mrs. Adjuster? How did you value these claims? What were the components? And if we're talking about an injury claim, how much did you assign to pain and suffering? How much did you assign to medical bills? How much did you assign to lost wages and economic losses? Oh, you didn't assign anything. You just gave them a general lump sum. Why didn't you pay, as Brad just said, why didn't you pay the undisputed portion to them immediately? Like in the example we used, $2,600. So you go through their file, you figure out how this claim has been specifically handled, you apply the laws of bad faith to them, which have now changed in benefit of the consumer. It's more favorable for the consumer, and then you can go through the file and take the depositions and prove your case.
Now, you said it's more favorable in benefit of the consumer. How is that?
There's a new law that's been passed. It's not necessarily a bad faith law, but it deals with measures that can be applied against an insurance company when they don't pay. For example, it was passed and it is now a new law in Colorado that if insurance companies don't pay or if they unreasonably delay or deny, those are new words. If they unreasonably delay or deny payment to you as they're insured, then they now can be held responsible for 2 times the amount of the covered benefit plus costs, plus in some instances attorney's fees. So there's a huge motivation factor by statute to make them pay you.
This is so important because sometimes what you find is an insurance company is saying we're not paying or we're delaying payment of a $1,000 bill or $1,200 bill to a doctor. And when you go to the attorney and say they won't pay this $1,200 bill, it's covered under the policy, they won't explain why. In the past, it was very difficult to be able to address that problem because the insurance company would say, who cares? By the time they get it, they'll never find an attorney who will pursue that case. Now, if you're entitled to get attorney's fees for the failure to pay, you can not only get your client's bill paid, but that client now gets the attorney's fees paid also. You're no longer in a situation where you have to look at the insured and say, it's not economically feasible. Why is that so important? Because insurance companies now are on notice that no matter how small the bill might be, it could be a bill that if the insured can't pay, if the injured person can't pay, a lot of times they're out of work, a lot of times they can't go to work. If they can't pay it, it's going to destroy their credit. Now it's a whole different ballgame for insurance companies to make sure that they don't unreasonably delay or deny your claim.
So when you guys are pursuing a bad faith case, do you request the entire insurance claims file, and then what do you do with it?
We request the entire insurance claims file. We go through, we index and make a table of contents of every page, and we make sure we understand what's on those pages. Sometimes those insurance claim file are this big. Sometimes they're twice this. But we request the file because we have to know what? We have to know how they valued your claim, how they evaluated your claim, and what action did they do. Take this for an example. If you get the insurance claims file and you find that in the file they did nothing, ever, but they just kept saying we're not going to pay you. This is a pretty clear example, and you will find that in their own documentation.
What other damages can someone recover when pursuing a bad faith claim?
You can recover your compensatory damages. Now there's case law that you can recover from the emotional experience and emotional trauma and a difference in individuals, how it affects you. And you can also make a request, not initially, but later you can make a request for punitive damages.
Damage to credit rating can be included within those damages. You don't want to. The idea is to make sure the insurance company understands that you're going to get fully compensated, and you're going to pursue all damages necessary to fully compensate the insured so the insured has the bill paid.
And Brad, you recently handled a workers' compensation bad faith case. Is that basically what we're talking about here, the same type of situation?
Well, there's duties that workers' comp that the work comp insurer has. We talk about this in another part of this seminar, where we talk about the fact that in a workers' compensation case, normally the employee who's been injured is going to the employer's doctors. The employer's insurance companies are paying the bills. The employer's insurance companies and doctors have the first say in what kind of medical care and treatment there's going to be. If in fact a person goes to all and jumps through all those hoops that they're supposed to jump through, and they start finding out that the insurance company is not willing to compensate them, not just for the bills that were sustained when they went to their employer's doctor, but also for their 2/3 of their average weekly wage, not being compensated for their disability, and for their permanent partial disability, or for their wage benefits they're supposed to be recovering. Yes, you hold those people responsible for the failure to pay. That can be in two particular forms. One can always be going to the work comp judge and asking for daily penalties. The other one can be filing an independent civil action in a court of law to require the insurance company to come and explain their conduct to a jury.
So these are very complicated cases, especially in light of the fact that you're requesting a huge claims file. And someone probably shouldn't take their chances with a rookie attorney in these type of cases.
Probably shouldn't take their chances with a rookie attorney. Need experienced lawyers, need somebody who understands the laws of bad faith, have been down that road before, knows what these insurance companies are about. And I tell you, you can recover. You have rights at home. You can be protected if your own insurance company mistreats you, and that's what the laws of bad faith are all about.
Listen, most of the time the adjusters that are making these decisions and are delaying and are using the excuses, they have more experience than the rookie attorney. Nothing against a rookie attorney, but the bottom line is the adjusters have been trained, they've been at it for years, they have experienced attorneys helping them. You don't want to be alone, and you don't want to have somebody brand new. You want to have somebody who's been through the fights and understands what their real purpose is, what the adjuster's real purpose is when the adjuster's not paying you.